J.D. Hoovener. I'm the owner here at Bold Patents Law Firm, and I'm a patent attorney. And thank you for having me on. This is quite an honor to be a part of this gift. And it's it's an amazing time, for a lot of reasons, especially for people that are kind of realizing that they can do a whole lot more from their home office, from their locations where they don't have to actually drive places. It's sort of opened up in a lot of ways, I think, people's minds to, even more now than ever about maybe owning their own company, right? Dreaming a little bit and thinking outside of the cubicle, right? And so it's even harder now, to actually have to get in your car and park in a parking lot and walk in and be sort of, reintroduced to this having to be in your desk. So it is, while there's certainly a place for that, hard work is needed all over. It's just, I think it actually has opened a lot of people's mind to working differently, and to finding ways to where they can add value for who they are, right? For their own passions and chase those passions in a very real way, without less burden of, a lot of the transportation and waste and time, actually going to physical places. So, this past year and a half has been wonderful, and it's been a blessing for our firm to be a part of that. We have inventor clients from around the country. We are fortunate enough to be practicing in a federal practice area, so we can serve inventors across the country in all 50 states. I don't think we have clients in all states, but it's like 30 or 40, I think. So it's incredible the kind of reach that we're able to have as a small firm. We have 6 attorneys. They all work from their home office. We've been virtual from the get-go, so we really were unaffected. And as I've kind of been alluding to, we've received quite a boon, from this change in this, type of economy. So anyway, I just am encouraged by all that, and this sort of platform you're putting together, Julie, and everyone that's involved, Jake and everybody, that you're doing is awesome. Especially for the youth, but I think it's also really nice for people that are watching them, cheering them on and seeing that they really are the next generation, and we all have to change, for the better. So I have I wasn't sure exactly on the forum for this, Julie. I wasn't sure if we'd have, live Q&A. We have only 4 people on the Zoom call. Do we have others that are maybe not on the Zoom call that could?
Yeah, we have folks that are on YouTube as well. So really the format is whatever you want to do. If you have a PowerPoint you want to show, you're welcome to, or you're welcome to just talk about your patent program or your firm, and maybe talk about some of the things that are most commonly asked, and we can ask people on YouTube to send in questions, whatever you want us to do.
Yeah, I want as many questions as I can get. I mean, there's nothing better than real live questions, and there's no question that is too basic. I love it. So just bring on any questions, anybody, even of course, including those people here. Is it Belen? How do you say your name? Okay, I couldn't quite hear you. You might have been muted.
Belen.
Belen, okay, great. Hi there, nice to see you. And yeah, please, your questions are welcome too if you have anything along the way. I do have sort of a backup plan. I had a presentation, Julie, so I could share my screen.
Yes, absolutely.
But there's nothing worse than listening to an attorney talk for like a half hour. Like that's just going to be boring for everybody.
Yeah, I could think of something worse. How about an attorney asking you questions like when you're sitting next to a judge?
Oh my gosh,
that would be worse.
Yeah, I agree. I think I'm really, again, lucky that this area of legal services, because we don't work with people that have to hire an attorney, right? Some people are stuck with that. I mean, certainly in like the criminal domain, for example, they're not desperate, or they're not angry. They're inventors, and it's like they're hopeful and they need your help. But it's not like something bad has happened. Something good has happened, and they want something even better. They want to share it, and they want to be rewarded for their innovation. So, okay, I can share, but jump in, interrupt me right away.
We are starting to get questions already, so we can hold them till you're done presenting, or we can ask you now, whatever you want to do.
Hey, fire away with the first one you saw.
Okay, hold on a second. Let me make sure this one. Okay. Wait a minute. How does the patent program work? That's a big question.
Program. Well, okay. So the USPTO, maybe we'll start there. The United States Patent and Trademark Office is a government entity, and they are the government administrative body that gives patents, right? They award patents to inventors that are able to prove to an examiner that their invention is novel, non-obvious, and has utility. Okay, those are the 3 requirements. All you got to do to get a patent. And there's been 11 million patents issued. Not everybody knows that. That's a lot. Okay, so in that sense, the Constitution, which is where the patent law began, and that's where it's founded in Article 1, Section 8, Clause 8. So in 200-300 years, not that much time. So what I'm saying is, you can get the next patent. You can do it. All right. Don't think it's this unbelievable hard thing to do. It is hard to do right. So I'll get to that later. So anyway, the USPTO awards patents, and law firms out there like ours help inventors write, research, and write, in my opinion, better applications than inventors can write on their own. And we can help you secure broader rights in terms of what the patent gives you protections on if you work with an attorney. And we can help you navigate through and argue with the examiner and help you get a more valuable patent. So once you get a patent, no matter what the claims are, you get 20 years. 20 years is a long time of a monopoly, right? You're the only one in the whole country that's able to make, use, and sell that invention without your permission, right? So it's a huge amount of time that, for you sharing with the world what you've discovered, what you've created. The U.S. government says, awesome, you are wonderful. We're going to give you 20 years of being the only one able to make money on this. Thank you, congrats. But then after 20 years, it belongs to everybody, right? We all become smarter. And even during that time, we're going to publish it. So all of your competitors, everyone in the whole country is going to be able to see what you've done and thank you for it. And yeah, they're probably going to work on the next improvement, right? They're probably going to work on it even well before that 20 years is up. So it's a way for us to, and how we have likely, in my opinion, been, the #1 innovation country in the world for quite some time. Maybe, we're being challenged lately, but that's why we've kind of led the pack. It's one of the major reasons why we've really incentivized that. So long story short, that's how the patent program works. Any more questions on that or any more details I can go into?
Yes, later. We have one other question here. Can you patent a product while still making it open source?
Can you patent a product while it's open source? Yeah, but you want to file it first, okay? You want to, so don't do open source and share it with everybody and then try to go get a patent. That's going to be pretty challenging. In the United States, there actually is a grace period, right? Because they know some of these entrepreneurs are just go-getters and they just can't help themselves and they want to go share it with the world. So in the US alone, there's only a couple of the countries that allow this grace period. Is if you shared it and it's been less than a year from when it went public, you can still file the patent application. But if it's been more than a year, if it's been shared with the public, thank you very much for sharing it, but we're not going to be able to get you a patent on it. Okay. In other countries around the world, they are very strict in that mind that if it was ever been shared publicly, it is not eligible for getting a patent on. And those two concepts really are polar opposites, right? Obviously, there's this altruistic notion of, hey, I just want to share my knowledge with the world, right? Peace, everybody. This is awesome. And let's just all share and be happy. That's wonderful. And if you feel that way, you want to be philanthropic about what you've created and discovered, share it as loudly and as much as you can. But that is not what the patent system is all about. The patent system is about making money. So if you want to make money, go get a patent. If you don't care about money, not interested in capitalistic kind of notions, go share it with the world. Go publish it and go open source. So they really are very extreme difference. And so kind of think about what your goals are and how you think it's going to be able to get the impact you want to have in the world, whether it's through monetization or if it's through other means.
I see. So there is another question here. So the patent is on a per country basis?
Yes. Yeah, there are patent laws and they are different in every single country. What is nice is that a long time ago, so a lot of smart people came together and they formed a treaty. And it's called the Patent Cooperation Treaty, the PCT. And it's great. I mean, almost every country you've ever heard of. And for some reason, Argentina is the only country that hasn't signed on. I mean, any country you've ever heard of, 130 countries have signed on. And so what happens is you apply for that. You get to this national You file in the US, then you file the PCT, and it'll allow you to file into any of those countries that are part of that treaty using the same priority date. So you don't have to write separate applications in all the countries you want to seek rights into, but you eventually have to hire an attorney in each of those countries, and it is quite a bit of work, and you do have to pay separate filing fees for each of the countries. They all have their own rules and little sticking points, and you do have to hire translators to get that into the right language so their examiners can read it and so forth. But it all depends, firstly on is there a demand for what you're trying to patent in that country, and it kind of helps you with deciding whether it's going to be worth it, to spend the money and invest in acquiring that asset for it to be worthwhile.
So we have here another question from the Institute of Inventors and Innovators.
This is great. I love it. You guys are great. Keep them coming.
Is the best time to get a patent or intellectual property protection for an invention idea?
It's the best time. Okay, and this is great. So it depends on a lot of things, but even though we are patent attorneys, right, and the default answer you would assume is like, now, let's file, let's do it. That's not always the case. And I think one of the places where we're most valuable, especially for our first-time inventors, is with the research up front. So before filing, helping inventors understand eligibility. Is what I've invented, what I've created, is it even eligible under the patent laws? And then two, is it patentable, and how patentable is it? So eligibility, in terms of what you can patent, is it has to be a machine, article of manufacture, composition of matter, which is kind of like a chemical, or any type of amalgam of materials, or a processor method. And that covers a lot. But what it doesn't cover are things that are laws of nature, right? And sometimes you create or find discoveries that are more equations, right? Physics, right? They're all based upon gravity or some sort of something that's innate in nature. And those are natural phenomena, and those are not patent eligible. And also, if you're just trying to patent an algorithm alone, it's just mathematics. There's no practical application in the real world. It's not going to be eligible either. So that first threshold question is really important. On top of all those sort of patentability questions, there's additional layer is if you've got a company or if you've got a sophisticated enough product and you've created it, before you seek patent protection, you should always ask yourself the question. This is a threshold question in terms of, should I patent or should I keep it as a trade secret? Once you sell it, once you sell what you're developing, put yourself in your competitor's shoes. They buy it. Could they reverse engineer it and rip it off and make it as if it were their own? If the answer is yeah, they could easily figure out how to reverse engineer it and do it on their own, you should look toward patent protection. If you think there's no way, even if they broke it down or chemically analyzed it, right, you can't figure out how that Coca-Cola is made, right? You can't actually figure out how they heated the right, syrups or what they added. Sure, you can tell what elements are in there or what, chemicals are in there, but you can't tell how they made it. That's why it's a trade secret. So kind of that reverse engineerability test is really important too, making up that decision.
Okay, next question is interesting because we are in such an international setting. They ask, how different is the US patent system from the systems in other countries?
Well, I am licensed here only in the US, and unfortunately I can't answer that very thoroughly because like I said, I've not experienced in the laws of other countries. What I can say is that they all generally follow a similar process where there is a search where the examiner has to conduct a search. There's an examiner in almost every country I've ever heard of. There's an examination based on their rules in the country, which are mostly around, is it new? And is it like anything else that's ever been filed or known in the field? And if not, then we're gonna get a patent for it. And I think it's still true that most countries, patent laws were established after the United States. And in other words, so the US is still looked at as, in a way, a leader. And so what happens a lot with inventors that we help is we'll work hard and get it through examination, and the US examiner says, yep, looks good. We're gonna issue this to patent. And while it's pending in China or South Korea or Australia, and those examiners see that and they're like, oh, awesome. it's allowed too. We're good to go. US said that's good. We think it's good too. So it helps in a way. And so there is definitely, the philosophy is really the same across the board, certainly for the member countries in that PCT treaty.
I think we have time for a couple more questions. The first one would be, what is the difference between first to file and first to invent? Yes,
absolutely. Yeah, this law changed in 2013, and it's still very important. And a lot of, inventors, inventors' mothers and fathers and grandmothers and grandfathers now are giving bad advice, right? They will tell you, oh, get your inventor's notebook and write all your inventions down and go get it stamped and notarized, because that's what's important. And that is unfortunately no longer the case. That won't do you any good. If you've really discovered anything and you feel like you've invented something that is important and powerful, you need to talk to the patent attorney and work to get it filed as soon as possible. It doesn't matter who invents it first anymore in the US. What matters is who files that invention first at the patent office. So it's a big change. The underpinning, the theory behind it, of course, is that the US government doesn't want inventors sort of toiling away, sitting on inventions. When you find something else that's new, we need to hear about it as soon as possible. We all want to we need to try to stay up with the pace of economy and the way technology is moving, and they just want to make sure there's urgency to share, to get that reciprocation of, hey, I want to tell the world how I solved the problem. The U.S. government gives you that 20-year monopoly. They want to kind of speed up that cycle a little bit. That was the thought, and that's how the rest of the world does it too. We were kind of one of the last to adopt that philosophy. And there were a lot of really weird legal issues that came up where, multiple inventors would come in out of the woodwork. So, oh, I invented it first. No, I invented it first. And they would have a lengthy, interference type meeting, and it kind of clogged up the court system.
Very interesting. How much would a consulting cost?
With our firm? Yes,
I guess so, yes.
Yes, we do charge. We charge $225 for a half-hour consultation, and you'll get an answer on, is your invention eligible? That's one of the things we do guarantee in that meeting. And then, of course, the conversation could go anywhere, and we'll help you think about what to do next. Is patenting the right area for you? What else should we consider? And then typically the next step after that is, if we're going to move forward, is for us to outline the project of doing the research, right? Beginning, worldwide search for publications and patents that are out there to confirm that what you've discovered is new, what you've invented is non-obvious. So hope it helps a little bit.
So we have a question from Ranjit. If I make a product open source, can someone else patent it to prevent others from working on it?
No, that is the beauty of publication. Certainly, for a couple of reasons. One, if you're the inventor of the invention and you publish it, and someone else sees it and then they file it, they've just committed fraud, right? They are not the inventor. You have to be the inventor to file as if it was theirs. So that's issue number one. But issue number two is that you published it before they filed it. So the examiner will find it if they do their job right, and they'll be able to invalidate and they'll reject the application. Even if the examiner doesn't find it, you can actually send it. You can submit it to the patent office and say, hey, examiner, you might have missed this, or just in case, this is on the way. I just published this. But in most cases, the examiners are very good. And so I would just say, if you're going to publish it and share it open source, don't be quiet about it. Be very loud about it. Share it everywhere. If your goals are to, and companies do this all the time, big companies. IBM is famous for doing defensive publications. They have their arms in a lot of different things, but if they want to prevent their competitors from getting a patent on something and they stumble on something, but if they don't actually plan to monetize it, they'll just publish it in a huge journal and just laugh at their competition how they can't file a patent on it now.
So, what happens if you make a mistake on a patent application?
Mistake. We never make mistakes. That's a great question. I don't know. A good examiner will bring that out, I suppose. One of the classic mistakes that inventors and patent attorneys and agents make is they don't properly describe the invention in a way that fully enables the invention the way that it's being claimed. So I know it's a lot to be said. So when you write a patent application, a utility application, there are 3 different types of patents: utility, design, and plant patents. So you can actually patent things that grow up from the ground. Design patents cover just the shapes of things. Utility patents protect things that do things, right? It's the most typical, and that's what I've been talking about. Yeah, if you're claiming, this flashlight, flashlight with a mirror, with a cover and 2 separate lenses, one for strobe action, one for major luminescence, and an LED, and it's got this chamber and a back position here, and you're claiming the whole entire flashlight. But in the written description, in the application, you actually don't describe how this back portion attaches. You just say, yeah, there's a back portion. But in your claim, you actually talk about how there's a back portion and how it can be screwed on and how it has the electrodes positive and negative. The examiner is going to say, nah, yes, you didn't tell me. You didn't say how this is going to attach. You didn't say the different mechanisms. You didn't provide the structure. So then you go back and make amendments to the application to provide that antecedent basis. I don't know, kind of a weird example. There's lots of ways to goof up on a patent application. And that's why I usually recommend that you hire a professional that does it. And the inventor, oftentimes we'll hear they're trying to save money, they're bootstrapping. There's a lot of reasons why an inventor might want to try to file it on their own. But it's like a lot of things. Like it's going to be worth it in the end. If this invention is that important to you and it might be a future company, you need to do it right and invest with hiring a professional. When you get to the point to where you're making a lot of money, you're not going to want to do your taxes on your own. You want to hire a CPA and do it right. In the same way, you need to not spend your time learning about patent law, how to write it. You should spend your time working on the next version of your invention, working on your business plan, developing what your strengths are, instead of trying to develop a skill set that's really very foreign and that attorneys spend all day doing.
So next question. This is a follow-up from the Institute of Inventors and Innovators of South Africa. I do not know enough about intellectual property in general, but I can tell you that here in South Africa, we do not have examiners, FYI.
Oh. Wow. How do they do it? They just give you a patent? I don't know. That seems kind of wild. Good to know. I'll make a note. No examiners in South Africa. Okay. Wow. Well, if I'm an inventor in South Africa, I'm going to want to file an application because it sounds like they're easier to come by, perhaps, than other countries. So,
can design ideas be patented?
Design? Yes. So, okay, designs are you get protections over a drawing. Design patents are like the shape of the flashlight. Like the actual, you see it has little contours, it's got a little triangle feature and kind of a trapezoid, right? Those are all design elements. Sure, they might have some ergonomic functionality to them, but the actual 3-dimensional shape, that's what's protected on a design patent. I mean, you have to almost think about it like a sculpture. That's how design patents are protected. So if another, it doesn't have to be a flashlight, but if some other element, like a product, let's say this is like a really small, like club, you're gonna if someone's self-defense, right? But if it's shaped the same way, even if it's not a flashlight at all, it likely would infringe that design, right? Because you get protections on it regardless of what it actually does. So utility patents are, of course, is the functional, right? And that's where you get claims over what's written, the written claims. The fact that it has a little button on the back, it has ridges, and it has a handle that fits the hand really well. So those are the economic, the utility side of it. So certainly lots of design patents are issued. We're over 1 million now design patents. But for some reason, there's 10 times as many utility patents that have been issued.
So one last question. Can you patent an app?
Yes. Yeah, in fact, I wrote a really long blog article about that. You can search Bold Patents Law Firm, software app, can I patent an app? I've got like a 13-step approach. And it starts with that eligibility threshold. We'll walk you through. I mean, a lot of software, people get confused. The actual code of the language you write, is not patentable. That's like any other writing, like you have in telling a story in a book. That's protected under copyright. because the story can be told in a million different ways, right? But it's actually what you get patent protection on is what the app does, functionally. Who's involved, what information travels where, how is it stored, how is it analyzed and reproduced, what is it providing in terms of veracity or protection or security, is it quicker, more efficient, whatever it is doing, that's what's potentially protectable. But it has to meet the same requirements, has to be new and non-obvious in order to get a patent. So absolutely, yes, it is eligible, and we see a lot of those these days.
JD, can I ask you one question, please?
You bet.
A lot of times I see on products, it has the phrase patent pending. Okay.
Yep.
Is that a legal statement or just sort of a wish?
Well,
let me tell you a story. I know somebody who creates lots of things. He puts patent pending on everything. He's not actually filing any patents, but he figures it's going to keep people away from trying to, jump in and do something.
Well, that's a shame. Tell your buddy you got to file a patent. That isn't right. And to me, that's a bit of a fraud. That's a fraudulent thing to put on.
Is it illegal or just not nice?
I don't know. Jake. You got me. Don't do it. Don't falsely label. I think false labeling, right, in the sort of Consumer Protection Act domain, I'm pretty sure that's a tort, Jake. I'm pretty sure. I'm not a litigator. I'm not a civil litigator. That's where I would put that in a civil litigation tort. Is you've defrauded. You put false information on your product being sold. That's a no-no. Don't do it. So I would have a chat with your buddy, and you should only put that on if you filed a patent application. It doesn't matter what kind of application, it could be a provisional, non-provisional, a design, a plant patent, but you must have actually filed it. And once it gets patented, you can then say patented and put the patent number in there. So that's a good one, Jake. I can get back to you on it, but that's my hunch is that.
Just to defend myself, I didn't say this was a friend of mine. I said this was somebody I knew. Okay.
Oh, somebody else. I got you. All right, we'll pass it along to somebody.
No, I didn't want you to think.
Well, they might become your friend once you tell them that they should no longer do that because you'd be saving them a heap of trouble. With that, it's one of those deals. Like if it remains perhaps a hobby or they only sell a handful, they'll probably never hear about it. But if it becomes huge, takes off, that's when they'll hear about it. So if they plan to be successful, they should do it right.
JD, I have a question for you and then a quick comment before we let you go.
Sure thing.
One is, where does one find your books?
Yes, it's available on Amazon, and you can go look on there. I've got a Kindle e-reader version and the paperback version available. And actually, the second edition just came out. I don't even have a copy myself. I've got to order some author copies. You can also get a free copy if you decide to take action and schedule a consultation. Of course, you got to drop $225 to do that, but we throw the book in for free for those that do decide to make a commitment. That's where you get the book.
Okay.
Yeah, absolutely. I just actually released a new one. It's behind me real quick. I'm talking books. I love writing books.
Which one's the new one?
Brand new. This is the Physician's Guide to Patents.
Wow.
We have some of my favorite clients are physicians, and you're like, oh, physicians, but no, there's actually a ton of people that are actually physicians. I put dentists in that pool, chiropractors and orthopedic surgeons. I mean, all sorts of stuff, neurologists. So they're all inventing, and it's pretty fascinating,
Right.
Anyway. So yeah, I got that book out there too. For
and the
out
comment
there.
I wanted to make was just to thank you very much for your participation this year in Innovation World's National Innovator Challenge, for which the top challengers were invited to UIA TV's Youth Innovator program. So we had a 5-part series, and JD was actually the first. He led that series, and we had the young innovators online with us on YouTube TV, asking them questions, all sorts of questions, and it was fabulous. And we thank you very much for your commitment to youth innovation, and we look forward to seeing you back next year there, and at future global innovation field trips with new information to share with the world.
Absolutely. Yes. And a quick
you.
plug, I do a live broadcast every Wednesday, 9 a.m. Pacific, where I do just this and answer live questions. So if anybody didn't get a chance to ask their question, I'll be happy to answer it Wednesday, 9 o'clock Pacific.
And if they don't know how to get to that, they can go to the Innovation World website and go to service providers and click on bold patents. And I think it will take them to a link to that.
Perfect.
Yeah.
Thank you, Julie. Thanks, Jake.
Thank you.
Gentlemen,
Bye-bye.
Take care.
Bye-bye. Bye-bye.